And we're back. Now that this book is put in order, it's so much fucking fun. This is a blast, guys. Chapter 4, a bank attorney's response. This is a real response filed in a real court. A number of people have filed lawsuits against banks. If you study the lawsuits, you will learn from other people's mistakes. The following is a bank attorney's court response to a suit against the bank. The defendant, Mr. Smith, in pro per persona, please take notice that the plaintiff, cross-defendant Bank Z, will and hereby does demur, which a demur is something a man does. It's a spiritual thing. It's not so much. It's on the lawful side of the court, not a legal thing. But legal, the public likes to emulate the private side. Okay, they're very envious on the public side of the private side. And thus they adopt things like habeas corpus, writ of mandamus, quo warranto, demur, and so forth. Okay, so what you have on the private side is auxiliary. Let me see if I get this right. You have, oh fuck, it's gonna evade me. It's auxiliary and exclusive, and there's another one. And on the public side, they also have the same thing. And because of that, they are mirroring the private side, which would be lawful, and they're moving it over to the legal side. And under the Judicature Act of 1781, I believe it is, or 1871, the Judicature Act, they combined and commingled the Roman civil equity with Roman civil law. And so when you're hearing them use equity in the public sector in administrative courts, do not misconstrue or confuse it for what it really is. It is not equity as in the exclusive jurisdiction of equity. It's Roman civil equity, which is not in your favor. Demur. To the cross-complaint of cross-complainants, Miss Smith, in the above entitled case, the demurred is based upon the following. This demur is based on Codes of Civil Procedures, paragraph 430.10e. In the complaint fails to state sufficient facts to support the cause of action set forth therein. This demur is based on this notice and notice the attachment memorandum of points of and authorities, the cross-complaint on file with the court, all other documents and records on file with the court, and on such oral arguments as the court may require at the hearing on the demurrer. Memorandum of points and authorities. Statements of facts. Bank Z is attempting to collect on a default credit card account. Bank Z requests that the court take judicial notice of certain of the following facts, which are not in the four corners of the cross-complaint because are based on articles in the new news media. The cross-complaint runs from the unintelligible to ridiculous and suspicious. Certainly it fails to state facts sufficient to support any of the causes of action therein. Attached to the complaint and incorporated by reference therein, paragraph FR3, in the cause of action for fraud are a series of letters and other documents from the debtors which contain a dose of the type of quasi-legal arguments that are being circulated on the internet and elsewhere by persons who claim that such allegations will get debtors out of having to pay their debts. Their sales pitch, based on a rejection of the U.S. legal and economic system, also advocate threats against the creditor of what are nothing more than bogus claims of fraud, conspiracy, extortion, and peonage. See letter attached to the cross-complaint dated September 25th, 1996. These pitches further represent that if a lawsuit is filed by the creditor, the filing of a cross-complaint by the debtor accusing the creditor of fraud and a flurry of motions and other documents will discourage creditors from pursuing their claim. The complaint filed by Bank Z is nothing more than a routine collection case on the balance of a credit card debt which is in default. In response, the cross-complaint set forth the spurious causes of action which the antisocial groups advocate. The first is FR2, intentional or negligent misstatements, in that Bank Z was in the business of to lend money. However, the cross-complaint does not state what represents a material fact were made by Bank Z. In the next paragraph, the statement is made. In reality, they only extend credit and do not have any money to lend. Nowhere are facts pleaded which show that Bank Z made any misrepresentation of material facts. Even if Bank Z did borrow money to pay the merchants with whom cross complaints obtained credit card credit, this fact is not a basis for fraud. Bank Z obviously never represents to any potential cardholder where it gets its funds, and until cross complaints state with some specificity who made any material representation to them on this point, and that it was the basis for their seeking a credit card, and that they were harmed as a result of the fact that Bank Z may have borrower its funds, cross complaints have offered absolutely no facts upon which to base any cause of action for fraud. Under the second cause of action, FR3, concealment cross-complaint has not stated any material facts which Bank Z had a duty to reveal. Again, there is no duty to reveal to an applicant or an application for a credit card where the card company gets the funds that it pays the merchant with whom the cardholder deals and uses the card. Under the third cause of action, FR4, promises made without intent to perform, cross complaints have filed to allege what acts Bank Z failed to perform. Since all Bank Z promised to do was furnish a card, credit the account of the merchant with whom cross complaints use the card, and then allow cardholder to repay Bank Z on a monthly billing basis. There are no facts alleged to show that Bank Z did not do exactly that. Finally, the cross complaint sets forth a dollar amount of punitive damages. 2. Basis for demur. California Code of Civil Procedures 430.10 states that a party against whom a cross-complaint has been filed may object to the pleadings on any one of several grounds, including that E, the pleading does not state facts sufficient to constitute a cause of action. Additionally, Code of Civil Procedure 430.50 states a demur to a complaint where a cross-complaint may be to the whole complaint or cross-complaint or to any of the causes of action therein. A complaint seeking punitive damages may not allege the amount of punitive sought. Code of Civil Procedure 3295E. The cross-complaint does not state facts sufficient for the stated cause of action. The court needed only to look at the letters and threats sent to the cross-defendant Bank Z by cross-complainants, which are attached to and made part of the cross-complaint, and at the wording of the cross-complaint to see that not only are the damages claimed wholly without factual and legal foundation, but that the entire cross-complaint fails to state any legal recognizable cause of action. The essential allegation of an action for fraud or deceit are false representation as to a material fact, knowledge of its falsity, intent to defraud, and justifiable reliance result in damage. William versus Perry, Price, Williams, and Russell, 1986. It is well established that in order to state a cause of action for fraud, a complaint must state with particularity the fact upon which recovery may be had, as stated in Hall versus Department of Adoption of Los Angeles County. The general rules with respect to the pleadings pleading a cause of action in fraud and duress is stated in Witkin versus California Procedures, 2nd edition, section 574. Fraud must be specifically pleaded. The effect of this rule is twofold. A general pleading of the legal conclusion of fraud is not sufficient. The fact constituting the fraud must be alleged. B. Every element of the cause of action for fraud must be alleged in the proper manner, i.e., factually and specifically, and the policy of liberal construction of the pleading will not ordinarily be invoked to sustain a pleading which is defective in any material respect. As to claiming a corporation committed fraud, the court, in upholding a demur in Manson versus Drug Inc., 1939, the corporation could speak and act only through their agent and servant. Therefore, it was material to the state to state the names of such agent and servants, what they said and did material to the cause of action. When the event happens, citations omitted, fraud is never presumed. If the plaintiff would charge the defendant corporation with making fraudulent misrepresentations, it was necessary for him to allege the name of the person who spoke, his authority to speak, to whom he spoke, what he said or wrote, and when it was said or written. It is obvious from the cross-complaint that cross-complainants are alleging the sorts of general facts about the credit structure of this country, particularly as it applies to credit cards issuers, and not to any representation made by Bank Z to these credit holder upon which they relied to request the card. Therefore, the demur to these spurious causes of action should be sustained without leave to amend. Conclusion. The court need only to look at the documentation generated by the cross-complainants to see that the demur should be granted without leave of amend. There is no way such a cross-complaint can be amended and comply with the expected principles of California business law, including any accepted basis for alleged fraud. The court may suspect from their tacit that these cardholders are irresponsible debtors. They enjoy the benefit of the credit card and then refuse to pay the account. Bank Z should be put to no further expenses to deal with any more such foolishness, which would only add to the amount that will be owed by cardholder and possibly add to a further uncollectible amount. Even sanctions may not deter this type of debtor, as these too may be uncollectible. Therefore, the demur should be granted without leave to amend, and perhaps this collection case can be quickly disposed of with some minimal discovery and a motion for summary judgment, signed by bank's attorney. This is a great example of what to expect if you sue a bank. If you examine this bank attorney's document, you will find 1. He never proved the opposing party's banking arguments were wrong. 2. He called it bogus claims of fraud, quasi-legal arguments by antisocial groups. 3. He claims the bank was threatened. And 4. The attorney claims Mr. Smith did not state what representation of material facts were made by the bank. Mr. Smith could have easily corrected this by taking the agreement and showing how the agreement claims bank was to loan and Mr. Smith was to be the borrower, and the bank charged interest for the alleged loan. 5. The attorney claims the bank has no duty to explain where the funds came from. The bank charged Mr. Smith as if the bank loaned the bank's money. The fact is, the bank received valuable consideration from Mr. Smith, which was used to pay the merchant, and the bank never loaned Mr. Smith their own money. The bank believes the agreement is that Mr. Smith provides the funding to pay the merchant when he uses the credit card, and then must pay the bank back the principal and interest as if they loaned their money. The agreement only claims the bank is to loan their money. There is no agreement that Mr. Smith is to provide the funds to purchase the merchandise and then repay the bank as if the bank loaned their money. In an actual lawsuit, you would word this differently. When even bringing up fraud, why not just discuss a breach of the agreement as to who is to provide the funding for the purchase of the fund or fund the check? All you want to do is embarrass the other side into saying the bank provides the funding, not you. That is all the attorney could say. When the attorney makes this false statement bringing fraud on the court, you nail them with the documentation. 6. Mr. Smith should have stated that the bank failed to loan the money and used the funds from Mr. Smith to return to him, falsely claiming it was a loan from the bank instead of the fact that it was a return of capital. Number 7, Mr. Smith needed not discuss that he did not talk to anyone. He should have simply stated that the credit card company mailed him an agreement of which he relied upon. The agreement claimed he was to borrow funds. It never mentioned he was to deposit money, exchange funds for a check, which the bank then claims is a bank loan check back to him, or that he was to be the lender or creditor to the credit card company. A few corrections in this suit could have stopped the bank attorney from demurring. Did the attorney commit a felony? The attorney knows contract law, or he could not be an attorney. The attorney admitted he knew about the opposing arguments. The attorney refuses to tell us who provides the funds for the bank loan check. Is it the borrower or the bank? The attorney can read my book. The attorney has the information and still brought fraud on the court by making false statements. The Federal Reserve Bank publications agree we are right and the bank attorney is wrong. I think the attorney should stop making false statements or leave the law profession altogether. Chapter 5, a judge's response. This is a real response filed in a real court case. An individual sued a credit card company alleging that the bank defrauded the credit card holder because the bank created money out of thin air and loaned it. The bank won. The judge wrote the following. Ruling on the defendant's motion for summary judgment, plaintiff Mr. Jones, proceeding pro se, filed a complaint against defendant Bank Y, seeking to avoid paying his credit card bill and alleging inter alia Bank Y credit card and lending practices are fraudulent. Plaintiff claims as damages $40,000 plus interest and cost. Bank Y counterclaimed for the full amount due on the Visa account, plus interest, penalties, and reasonable attorney's fees as provided for under the terms of the Visa agreement by Bank Y. Bank Y now moves pursuant to Federal Rule Civil Procedure 56 for summary judgment on all counts of its counterclaims and against plaintiff on all counts of this complaint for the reasons stated below. Bank Y's motion is granted. Background. In July 1994, plaintiff applied for a Visa card with Bank Y. His application was approved. He received a Visa card and used it between July 1994 and January 1995 to obtain goods and services. During that time, plaintiff never disputed the accuracy of any of the Visa statements. He never complained about the quality of the goods or services he purchased with the Visa card. Plaintiff made minimum monthly payments on the account until December 1994 when he reached his $3,000 credit limit. In January 1995, plaintiff failed for the first time to make his monthly minimum payment. Bank Y began sending plaintiff notice that his account was past due. Plaintiff filed a suit in Superior Court on February 20th, 1996, alleging inter alia breach of contract, fraud, and the intentional concealment of the creation of the money prior to the agreement, constructive fraud, failure to disclose, misrepresentation, and involuntary servitude. Bank Y removed the case to this court pursuant to Title 28, 1446. Bank Y then answered the asserted counterclaim against plaintiff for the amount due in the account, interest, late fees, and attorney's costs. Paper 12. Plaintiff has since filed an amended complaint, paper 31, which Bank Y has answered, paper 37. Plaintiff's allegations of fraud and misrepresentation stem from the accounting method used by the Bank Y. Plaintiff contends he did not understand either from the language of the Visa agreement or Bank Y's advertisement and materials, Bank Y's true accounting procedures. So ignorance of the law excuses no one, for all men are responsible for knowing the contracts they enter into. So his argument is frivolous and futile. All right. When he signed the application and Visa agreement, plaintiff believed Bank Y was loaning him actual money either from the bank assets or out of the money placed in the bank by depositors. In actuality, Bank Y keeps only a small percentage of its accounts in reserve. Plaintiff argues it is illegal for the bank to set up accounts and pay vendors with money created out of thin air, and Bank Y uses a use of accounting methods which do not involve 100% cash exchange constitutes both ultra-virus acts by the bank and fraud against clients. Plaintiff further argues that even if such accounting practices are legal, his Visa agreement with Bank Y is void because Bank Y fraudulently misrepresented and failed to disclose its accounting methods to the plaintiff. Plaintiff contends he would never have signed the Visa agreement. He's trying to allege denial of due process of law, but he never asked the question, right? So he's still on the hook. Nor used the Visa card had he known Bank Y's accounting methods. Bank Y answers that 1, its accounting methods are sound and legal under the state and federal law, and 2, the Visa agreement between Bank Y and plaintiff is fully enforceable. Bank Y counterclaims for breach of contract, arguing plaintiff breached his commitment under the Visa agreement to pay charges and interest. Number 2, discussion. Summary judgment is appropriate when all discovery together with the affidavit, if any, shows there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law. Essentially, the facts were stipulated to by the non-response of the defendant, who, although appears to have attempted to make a counterclaim based upon the fact that full disclosure was not had. Again, ignorance of the law excuses no man because all men are responsible for knowing the contracts they enter into, and he failed to ask proper questions. And so he got put on the hook. All right, he defaulted and he got screwed. And it was only because of his lack of knowledge. If he had had the knowledge, he could have whooped the shit out of him. Federal Reserve Civil Procedure 56C, when deciding a motion for summary judgment, a court must resolve all ambiguities and draw a reasonable inference in the light most favorable to the party opposing the motion. Twin Laboratories, Inc. versus Weider Health and Fitness, and Shockley versus Vermont State College. Once the movement has established a prima facie case, prima facie means that it can be destroyed. You know, a case is truly never closed. You can always reopen the issue, all right, because it's prima facie. It's not actually fact yet. It's been presumed and assumed to be fact because there was no proper interrogatories. There was no deposition done from the looks of what we can see here on its face. Case demonstrating the absence of a genuine issue of material fact. The non-moving party must come forward with enough evidence to allow a rational trier of the fact to find for the non-moving party. Matashita Electric Industrial Co. versus Zenith Radio Corp. If there is no issue of genuine fact and a rational fact finder could not find in the non-moving party's favor, then summary judgment is appropriate. And again, you can always weigh heavily on Trinsley versus Pagliaro and shut that attorney down real fucking fast. Anderson versus Liberty Lobby. Because plaintiff proceeds pro se, his complaint should be construed more liberally than complaints drafted by trained attorneys, Haynes versus Kern, and in general courts extended extra consideration to pro se plaintiffs, who is to be given special latitude on summary judgment motions. Valentine versus Hosinger, and in one of these cases I can remember when the appellate court said, now, you should, the judge should have instructed him on what he needed to do. to protect his rights. So they kick it back down to the lower court and say, now, Judge, now you tell that young man what he needs to do in order to amend his pleading so it's proper. However, a pro se party bald assertion unsupported by evidence will not overcome a summary judgment motion. Lee versus Colgan. A, plaintiff's claim. Plaintiff's contention, in essence, is that his visa agreement with the bank is void because Bank Y fraudulently concealed the nature of the credit it extended to plaintiff, thereby tricking him into signing the visa agreement and using the Visa card. The element of fraudulent concealment in Vermont or concealment of facts by one with knowledge or the means of knowledge and a duty to disclose, coupled with an intention to mislead or defraud. Bank of Vermont versus Lindenville Savings Bank and Trust Co. Also in Silva versus Stevens, there is no general duty to disclose facts absent inquiry. So absent your inquiry, there's no duty to disclose shit. All right. If you didn't ask, it's a don't ask, don't tell policy. All right. So it won't find in your favor if you don't, because remember, equity aids the vigilant, not the ones who slumber on their fucking rights. And liability for non-disclosure will arise only when there is a legal or equitable duty arising out of the relationship between the parties, citing White versus Pepin and other citations omitted. In this case, Bank Y had no obligation to give plaintiff a short course on its accounting procedures when he applied for a Visa card. Bank Y's accounting methods are perfectly legal, see Supernote 2, and it had no legal or equitable duty to appraise plaintiff of the particular way it handles each transaction. Furthermore, plaintiff has failed to demonstrate how or why Bank Y would have the intention to mislead or defraud him about its accounting practices. Moreover, the provisions of the Visa agreement are unambiguous. A provision in a contract is ambiguous only to the extent that reasonable people could differ as to its interpretation. Trustee of Net Reality Holding Trust versus AVCO Financial Services of Barre. Citations omitted. The question whether contract terms are ambiguous is for the court to decide as a matter of law. Citations omitted. If the contract is unambiguous, it must be given effect in accordance with the plain, ordinary, and popular meaning of its terms. Douglas versus Skiing Standard Inc. and Xavier versus Albro. The term of the Visa agreement are clear and unambiguous with respect to Bank Y's responsibilities to reimburse vendors for plaintiff's charges and plaintiff's responsibility to repay Bank Y those charges plus interest and fees. See memorandum in support of motion for summary judgment, page 42, Exhibit 1. Plaintiff admits he read and signed the Visa agreement and that he understood the terms of the Visa agreement when he read it. Plaintiff admits he used the credit card to purchase valuable goods and services. He understood he would be responsible for repaying Bank Y for the amount he charged on the card and for interest payments on that amount. See memorandum in support of motion for summary judgment, papers 42, Exhibit 3, deposition for Mr. Jones at 4I-2223 and 4-2-4445. This suggests the provisions of the Visa agreement are unambiguous even to the plaintiff who now protests them. Because there is no genuine issue of material fact for trial and defendant is entitled to judgment as a matter of law, summary judgment is granted. 22. Bank Y's counterclaims. Bank Y has counterclaimed against plaintiff for breach of contract and money had and received. The counterclaims mirror plaintiff's claim claims in that they call for enforcement of the agreement, which plaintiff contends is unenforceable in light of plaintiff's failure to raise any material issues which preclude enforcement of the agreement. Bank Y's motion for summary judgment on its counterclaim is granted. Conclusion: defendant's motion for summary judgment pursuant to Federal Rules Civil Procedure page 56 is granted. Defendant is asked to submit to the court its claim for damages on the counterclaim and any claim for attorney's fees. Defendant's motion for attorney's fees should comply with New York Assistance for Retarded Children versus Carey. On April 29, 1997, the chief judge in the state of Vermont signed this. If you read and study the judge's writing, he just told you how to sue banks. No one should ever sue a bank without following this judge's advice and the previous court case when that attorney told you how to sue a bank. Why make the same exact mistakes others have made and lose the same way? I disagree with the judge on the point that the credit card company sends you a credit card application. You apply. What document explains that the agreement is for the credit card holder to fund the money to buy the merchandise and then repay the credit card company the principal and interest on the money the credit card company would not loan? None I have seen. The plaintiff gave the judgment ammunition to fire back at the plaintiff, and he lost. The plaintiff used the proof I suggested in the 3 audit tapes I sell. It shows the bank took funds from the plaintiff and deposited the funds instead of the bank loaning their money to the plaintiff, as the plaintiff believed the agreement alleged. The bank withdrew funds from the plaintiff's transactions account without permission, authorization, or the plaintiff's knowledge and returned the funds to the plaintiff, falsely claiming the bank loaned the plaintiff money. If the plaintiff said this and gave the proof as I suggested, what could the bank or judge say? If the bank's attorney claimed this is false, now you have proof of false statements and the attorney brought fraud on the court. If the bank attorney claims this is how the bank operates, you claim it was never agreed to. If it is true, then you admit the bank did not make a loan. Now the term of the agreement are not clear and unambiguous as to whose account the money was to be withdrawn to fund the purchase of the merchandise. Now, the judge's cites can be used in your favor. Now the judge has professional proof you are right. Per the 3 audit tapes, the judge said you need 2 things to stop a summary judgment. You need a genuine material fact or issue. The issue is whose account funds the purchase of the merchandise, and you or the lender. Now, you have the professional proof needed if you follow the 3 audit cassette tapes. You just overcome the judge's 2 objections to stop the summary judgment. Do not discuss money versus credit or creating money out of thin air, or that they loaned you a bank liability or checkbook money or a bookkeeping entry. If you do, the judge and bank will make you look foolish. All they have to say is you got the merchandise and now you will not pay back the loan. Make them look foolish. The judge does not want to make it public that you provided the funds for the bank loan check and then must repay the bank the principal and interest on the money the bank refused to loan. The government does not want this faxed all over the nation. Remember, I am seeking a political solution, not a courtroom win. I am not giving legal advice, just illustration on how the banks and courts operate. You be the judge and jury. If you agree with me, I ask you to wake up everyone in America to the truth. When we return, we'll be hitting up Chapter 6, Expert Witness.